Welcome to Atlanta Business and Commercial Real Estate Law Podcast.
Hey everyone, welcome back to an all-new episode of the Atlanta Business and Commercial Real Estate Law Podcast with attorney Mark Battleson of Battleson Law, LLC. I'm your host, Mike Leon. You know, Mark here brings over 3 decades of experience across not only business law, but commercial real estate and deal structuring. And he's got a background that includes not only the legal work, but hands-on business roles. And in today's episode, we're going to be talking about contracts, right? I'm sure Mark sees contracts every freaking day. Most people use them, they sign them, maybe they don't read them, they rely on them, and they don't fully understand what they're agreeing to. And that's where the problems really start. Mark's going to break it down in just a second. Mark, it's good to see you as always. Let's 30,000 foot overview here. So explain what the main role and purpose of a contract is and why it really matters for small business owners.
Good to see you, Mike. This is basically like first day of law school in their contracts class, and it's everybody believes they know what a contract is, and certainly a handshake deal on most things can be a contract. Truly undocumented, just an agreement based upon some absolute certainty of price and product or whatever it is, and a handshake, and that can be a contract. Other than some exceptions such as real estate and what's called the statute of frauds, which is not really fraud. It's just something that can't be performed in 1 year. So, but for the most part, anything, even a handshake deal, can be a contract. So now getting into the meat of like why you would hire a lawyer is, the written contracts that are, everybody deals with. Every time you go into, basically sign anything for anybody, it's a contract. And that's a very generic term. That could be a non-disclosure agreement. It could be a sale of goods agreement. It could be sale of real estate, sale of a business, a loan agreement. All those are contracts. I mean, everything that is signed based upon 2 parties or more in an agreement is essentially a contract with of course some unique exceptions. And so within that, you're going to end up having obligations. And if you don't fulfill your obligations for either payment or delivery or whatever it is, confidentiality, then if it's properly drafted, there's probably explicit liability for you. And even without explicit liability, to the extent you don't live up to your obligations, you could be liable for damages, and to the extent the other party can prove it. So, it's pretty simple and basic, contract 1, not even 101, but it's an agreement between 2 parties, and that's really it.
Mark, I love the contract 1 and not 101. I do love that part, but let me ask you, it sounds simple, right? Get a contract, find a template online. A lot of people don't do this. They don't have a contract in place. Let's just take that in isolation. What are some of the issues that show up if you got a contract, but you don't have a contract, excuse me, and it's not, you don't have anything written up for the deal? Like, what are the issues you're going to run into without one?
Oh, without one, I mean, then it's a he said, she said kind of situation. I mean, unless you've got it on video or multiple witnesses who are going to come in and testify, you're really just dealing with somebody's honor. And look, there are plenty of honorable people that do handshake deals and they live up to them. And those are great people to do business with. And that they want the flexibility. Some people even say, I won't sign a contract. We're just going to, agree that this is going to be the deal. But if we ever want to change it, then it will stop, and people don't want to obligate themselves. So it's not necessarily 100% negative to not have a written contract, but just know that you don't have a whole lot of enforcement options. And even if you do, you're going to end up having to spend a ton of money on lawyers, corralling witnesses, corralling what's called peril evidence, which is evidence outside the 4 corners of maybe a poorly written contract, and it gets messy. So the whole point of a contract is to try to distill down the absolute agreement that you're going to have with somebody, and then get them to agree to the consequences if they don't live up to their side or you don't live up to your side. And right. It's a streamlining. People, get all wrapped up about, it's so much work and everything else. It's like, okay, well, imagine how much more work it's going to be if the other party doesn't live up to their obligations. And I cannot emphasize this enough. A written contract is only worth the wealth and the cooperation of the other side if they do go into default. You could have a very wealthy counterparty to a contract that just says, go ahead and sue me and I'll bury you in litigation. Or you could have a very broke person on the other side, or just an immoral person that's never going to live up to the written word. And don't do business with those people if you don't have to. It's judgment on the front end of who you're doing business with, and is so important, because that is, you just don't want to put yourself into a situation where you're going to have to litigate. If you anticipate litigation going into a contract, don't do business with those people.
Yeah, very well said. So let's get into the real life part of this, where people do sign a contract, but there's a lot of unclear language in that contract. What are parts of a contract that usually cause the confusion between these parties, especially if it's not written carefully?
Well, I mean, again, we're being very generic here, right? So it's hard to kind of identify a specific area, but I guess, just an example of what any contract is. First and foremost, it's better to have a letter of intent and understand the business terms on the front end, depending on the size of the deal. Certainly, it might be more efficient if it's just a 2 or 3 page consumer contract or something like that. Well, most people just sign that stuff blindly. But if it's a true arm's length business to business contract, or employer agreement, employment agreement, and with a non-compete and things like that, there is no specific area that would jump out at me. There are business terms, there are default terms, and then there are the default remedies terms that are obviously the most important, to the extent that they're explicitly stated in the contract. And you just need to understand what your obligations are. Hey, what am I signing up to do? First off, in the letter of intent, that should have the business terms associated with it that kind of outlines the quote handshake deal that's non-binding. And then that business agreement then is then applied to an actual contract that has enforceability provisions on it, et cetera, in the event of a default. And ultimately, if you either don't have the patience or the experience to review a contract and understand every single word in it, you're taking a risk. I mean, you may miss something, and it takes a lot of experience to read something that's hyper technical. Now, if it's simple, maybe you don't need a lawyer. But if it's something that has any level of complexity that's based upon external laws in particular, such as non-compete agreements and things like that, there's what's called a Restrictive Covenants Act in Georgia, and there's a lot of rules that go along with that and how those are enforced. So just reading something doesn't necessarily mean that you fully understand it and the ramifications. Right. And that's the same with real estate contracts. It's the same with finance contracts. It's the same with software contracts, et cetera. You got to really understand what you're signing up for. And the only way to do that is to read it carefully. If you don't understand it and or know how to negotiate it, then you're going to need a lawyer. And that's what I do.
Right. But it's true. It's necessary. Yeah. So let me ask you on that front, though. Can you kind of share a situation where a contract, maybe a client comes to you, the contract looked fine on the surface, but it caused like some issues later on because of something that seemed minor at the time?
I mean, I get people coming to me all the time with contracts that I haven't negotiated that have gone bad. I mean, I get that daily. And then, there's, I negotiate a lot of contracts too on the front end where the people are smart. And again, this is a self-serving statement, but the old saying, a stitch in time saves 9. If you spend several hours on the upfront on a contract and, it costs you $1,500 or something like that to go through a $100,000 contract, that is much better than trying to spend $50,000 litigating against that party on the other side. And going back to your question, on the litigation would come after a breach. The question as to something that seemed minor but then turned into litigation. The technicalities really come into play when people have just basically defaulted on the business terms. I mean, that's usually the biggest thing. It's not some super technical thing. The technicalities are then used in litigation to try to absolve by the defendant absolve themselves of some liability because of some super hyper technical issue, and or the plaintiff, the party that's aggrieved under the contract due to a breach, is trying to use a very technical thing to cause a breach on the other side. But I can't really get, there's hundreds of ways that could occur. It's just a matter of, they're very specific to the deal and, whatever the, law is. I mean, if it's under the UCC, Uniform Commercial Code, there may be even some level of standardization. I don't do a ton of, commercial sales work, which is under the UCC. But most of my contracts are, leases, franchise agreements, loans, and then just straight up purchase and sale agreements associated with operating businesses and or equipment that may be sold separately, as a arm's length sale when somebody's liquidating something or something like that.
Yeah.
But so I'm sorry, I probably didn't answer completely your question, but the unanticipated is what you're trying to avoid. So you want something that's clear and concise, to the point, and has little wiggle room for both parties, because then it's pretty clear when there's a breach. And as long as the person on the other side is cooperative, they don't want to get sued and spend a bunch of money in a lawsuit. So, if you got them by the short ones, and they know it, and they've got the money to pay you, and they're just not doing it because of some other reason, then, maybe it's worthwhile to file a lawsuit against them, and you're going to have a much more streamlined approach.
So Mark, on that front, like how important is it for contracts to kind of spell out what happens if things don't go as planned? Like, let's say contracts that involve payment schedules, deadlines, performance requirements, and these things kind of go awry. Like, what kind of details should the contract cover to cover those things that don't happen as planned?
I mean, certainly it depends on which side you're on, but I like everything down the middle of the fairway, unless the client really wants to kind of skew toward being really hard on the other party. It is much better to do business with people who are trying to hit the ball down the middle of the fairway and have a fair deal, so that it doesn't turn into somebody defaulting and having pressure on them and then digging their heels in, et cetera. It's, in my opinion, bad business to operate that way. So if there is a problem within the contract with delivery delays or warranty or some representation of warranty in a real estate or asset purchase agreement for a business, you want to give the opportunity to notify the party of the problem and then allow time for the party to cure the problem. Those are litigation avoidance measures. And then it's kind of like spanking somebody a little bit, saying, hey, the product wasn't delivered properly. The product wasn't what I intended. The real estate didn't, there's some flaw in it that was not disclosed. There's a flaw in this business that was not disclosed. You need to make good on this. And if you don't, then you're going to get sued for breach. And so to me, that's the best way to operate a business. And I try to operate as a lawyer, helping my clients that way, because, I do some litigation, but I'm not a day-to-day litigator anymore. I started out doing that, and it just doesn't fit my lifestyle. I'd rather do transactional work. Albeit on a select basis, I will jump in and do litigation on behalf of a client. But the whole point is to avoid litigation. You're not going into a business transaction with the idea of a lawsuit unless A, you're crazy, or B, you're super predatory and you're trying to jam somebody up in the other side. Mm-hmm. And quite frankly, I don't like working with people like that, and I don't. So it's just being litigation avoidant, giving opportunities to cure, even if it's not in the contract. If you're the aggrieved party or the party that was breached upon, you can always give the other party a little bit of wiggle room and get some kind of a forbearance agreement or some modification of the contract. And then if they default again, then you really whack them, and maybe with some additional penalties. It's your opportunity to negotiate with them, maybe new deal terms. Maybe they post additional collateral or something like that.
Right. Well, let me ask you, as we kind of put a bow on this episode. So that person that's listening to this right now, maybe they're drafting a contract, maybe they're reviewing a contract that's been presented to them. What's the best way you would advise them to start checking whether the document actually protects them instead of maybe creating more problems down the road?
Well, I mean, again, it depends on what it is, but the simple answer is, first off, before you ever saw the contract, there was probably some level of discussion and negotiation as to what was going to take place. And, whether you're the buyer or the seller or the, obligated party in an employment agreement as an employee on a restrictive covenants agreement, whatever it is, there's probably some intent there that you already know about. Then, if you're going to try to do this yourself, then you need to read every word very carefully and say, hey, does this clearly and unambiguously say exactly what I expect it to say? And there's going to be a lot of boilerplate stuff in there that you may say, God, how is this even relevant? Well, it's relevant very likely, especially if it's a form contract from another business. They've had some lawyer prepare that for them for exact reasons based upon all of their other business that they've done. And they want to make sure that they've got enforcement rights in the event of a default under the contract or a breach of the contract. So, if you're going to try to do this on your own, but be my guest. I've been doing this 30 years and I can tell you it's mind-numbingly boring reading. And there are a lot of technical gotchas that, I learned in 3 years of law school, 2 years with an MBA after that, and 30 years of in business and lawyering. And it's, I can't say it's fun, but it's my business. And so if you take the contract and you just read the first page and then sign it, and there's 9 pages behind it, hey, good luck. And you may end up going into this with the best of intentions, but then you may not realize that you've just put yourself at great risk. And then you default because you don't understand what you've obligated yourself to. And all of a sudden you're getting hit with a breach of contract, even though you really didn't have an intention to breach it. You just hit some technicality that you weren't even aware of that you had to live up to. So it's, there's the old saying, buyer beware. Well, there's another saying of he who represents himself as an idiot for a lawyer. And honestly, I mean, I've hired lawyers before, even though I'm a pretty well-rounded lawyer. I've hired lawyers for me personally and for business that I'm in, because it is always best to have a second set of eyes on it, even if you think you're very well experienced.
Yeah. Don't go it alone. I'm here to tell you, don't go it alone. Get a lawyer. I'm talking to one right now. Mark, thank you as always for the time and the insights. I appreciate it, man.
All right. Thank you very much.
That's it for today's episode of the Atlanta Business and Commercial Real Estate Law Podcast. If you need help, we've been saying it, if you need that help reviewing or drafting that contract for your business, do me a favor, visit battlesonlaw.com right now to connect with Mark and the team. And one more favor, as always, hit like, hit subscribe, leave a review, comment, share the episode with someone who needs to hear it. I'm Mike Leon. We'll see everybody next time.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.